Okay, I think I should start. Good afternoon from Tokyo. Welcome, everyone, and thank you for joining our TMT session on telemedicine and digital health data in Asia, covering the regulatory trends or gaps and issues. My name is Miriam Pereira, and I'm very honored to be moderating today's session. I'm a counsel at Ohebashi LPC and Partners, and I'm mainly involved in cross-border transactions. Telemedicine covers the delivery of healthcare services using information and communication technology, and its rapid growth, prompted by social distancing measures and strained healthcare facilities, is accompanied by the ever-growing importance of data privacy and protection. Hang on. So first, okay. So now for today's agenda, we will first have the presentations from our distinguished set of speakers. So we have Elsa Manahan and JJ Dicini from the Philippines. We will have Diana Lee from Shanghai, China. I hope she can join. She's having some technical difficulties at the moment. And we have Abadi Abi Tisnadistra from Jakarta, Indonesia, and Pankaj Singla from New Delhi, India. Thereafter, we will have a brief Q&A session. You may use the Q&A function of Zoom for your questions. And then there will be a separate networking event. So the link to the separate networking event will be shared in the chat box later. And now for our first presentation. Our first speaker is Elson Manahan. He is a vice president of St. Luke's Medical Center, serving as its chief legal and compliance officer, as well as the chief information security officer. He was the first data protection officer of the University of the Philippines, Diliman, as well as the first vice president and chief legal officer and data protection officer of the Unicapital Group of financial companies. Elson also teaches in UP Diliman's Technology Management Center and College of Law. He taught at UP Diliman's Department of Computer Science as well as the Commercial Law Department of De La Salle University. He is an MCLE lecturer of finance laws, data privacy, electronic evidence, and financial contracts drafting. Now, without further ado, I will turn over the floor to Elson.
Thank you, Marose, and thank you, dear participants, for joining us this afternoon. I will discuss the trends and challenges in telemedicine as experienced from the lens that we have in the Philippines. So, telemedicine is not a new thing, and but what happened during the pandemic is that as opposed to new technologies and new practices, the telemedicine was forced on the throats of people and the processes and the technologies we have, because we have no other choice to continue giving healthcare service despite the limitations of the pandemic. So all comfortable and usual healthcare practices have been disrupted and put into a halt, and we were all at every corner, one way or the other, in the healthcare industry, are forced to conduct something using alternative means, and telemedicine is one of the prominent ones. But so the trend now is telemedicine, and it sounds like a big word, but in reality, it's not as romantic as that, because telemedicine implies that you cure the person from a distance. But what really happens, like 85% of the time, is teleconsultation, not really telemedicine, because we have the limitations given by reality. Like when a doctor meets a patient virtually, he is limited. He cannot do even the simple things such as putting a stethoscope on the patient, or a simple thing such as looking at the eye of the patient. A doctor cannot do that. So how can he practice medicine without the aid of these conventional tools, and even without laboratory work done on the patient? Um, and he will be just forced to make the best guess he or she can do uh, on what the patient will disclose. So telemedicine, yes, we're on our way there, and in some advanced corners, it is being done that uh, from diagnosis to care and post care, all are being done remotely. But from experience on the ground, it is mostly teleconsultation and not even a full diagnosis. So that's a trend in telemedicine. But just to paint a picture, how does it happen in real life? Is it really so? Is there like an a new invention or technology out there that allows doctors to heal or cure conditions and diseases remotely? No, it's much less. It's much more grounded than that. In reality, there are two kind. First, to paint the picture, doctors are not employees of hospitals. In fact, a doctor can go from one hospital to another in a single day. We all know that. So the hospital doctors are not bound by hospital rules such as which platforms to use, which consent forms to use, how to conduct telemedicine. A hospital cannot impose these things on doctors. So that's one obstacle that we have to realize. And secondly, uh, the doctors have to adjust to patients, because a doctor cannot say, I only take Zoom calls, or I only take Viber calls, Viber video calls, and um, the patient has to suffer. You suffer, or I am sorry, I will not be able to treat you if you don't use the platform of my choice, or something like that. So doctors uh, have to find ways how to reach out to the patient as well. And this cuts across cross borders. That there are two kinds of patients. Well, back before the pandemic, we would call them those patients who can afford private rooms and those in public wards. But now we have tech-savvy patients, and patients who may not that be acquainted with how the internet works, or haven't even gotten the chance to use Zoom. More so for the those patients who are advanced in years and haven't gotten the opportunity to get to know these new technologies. So a challenge in that setup, given that picture, is that do doctors connect? So in reality, in our experience, they try to learn all the um, video conferencing platforms. It's not nothing special, because those are the ones available to the public. Even Facebook video calls are being used right now. I know there may be objections or concerns on security, etc. But in this time of pandemic, doctors are really have to hit the ground running, and have to march head first, instead of thinking, oh, I won't cure this person even though he's having a heart attack right now, because uh, Facebook video may not be the most secure platform. So they do it in whatever platform that the patient is comfortable with. And this is difficult in some patients who are technologically challenged, or in those quarters of the country which don't have access to the internet even. So for example, we even have experiences that some patients have to go to a small local government unit, and someone from that government office will open a webcam for them and tell them, oh sir, please look at this camera and talk to the doctor, okay, or speak loud, something like that. And of course, there are challenges. How do you get the consent in those forms? Do you have the patient sign a piece of paper? But how can you give the paper to the doctor in return? Or you can record consent over the video conferencing tool, but this is the common solution that we're doing right now. But we still have people sign consent forms in take a picture of it. It's not an original document because it's just a picture, but it's the next best thing we have in addition to recording the verbal consent. So these are things that we are facing. So that's the picture of telemedicine. It's really mostly teleconsultation, and we are faced with challenges because people, both doctors and patients, are not ready for this. Patients are not even ready how to use video conferencing platforms, not all of them. A specific, so let me go to the challenges of telemedicine. A specific challenge we have is diagnosis. Like I said, it's not that easy to pinpoint what is wrong with the patient and give the patient the proper treatment if you cannot even have some basic laboratory procedures or even take the basic blood pressure of the patient. You just have to rely on what the patient will disclose. And not all patients are that articulate when they're trying to describe what's happening in their bodies. And then after follow-up treatment, aftercare treatment is also a challenge because um, there's something about going to the doctor personally, physically. There's a sense of commitment that when the doctor tells you to go back to this clinic next month at this hour, you feel obligated because you've already invested a lot because you physically went to that clinic. But nowadays, a video call is very forgettable, and even a patient may even forget what the doctor said during a video call, and the doctor cannot track down the patient. And more so for the patients who again are technologically challenged, those who have to get a granddaughter's assistance just to make Zoom work for her. It won't be the easiest way for her to to follow up her treatment if that treatment is even necessary. Prescriptions is also a thing. These are the challenges that we have. I'm just laying out the challenges, and solutions will be discussed later on. But very generally, the trend now is really to focus on having remote partners so that to decentralize and therefore minimize the impact of having these long distance uh, telemedicine sessions. Another challenge we have in telemedicine is ensuring that everything is confidential because there's a reason why doctors' clinics are all segregated from each other. Uh, the whatever is spoken between the doctor and the patient should be confidential. But in telemedicine, you don't know where the patient is. For all you know, the patient is riding a bus while talking to you, or in a public internet cafe talking to you, and you are not sure if you are being recorded in return. Consent is also a tricky one. First, because like we said, doctors are not really employees of hospitals. So if from our experience, the best that we can do is to recommend consent forms, recommend the best platforms that can be used, but our doctors are not bound to use the consent forms that we are trying to impose on them. And this is understandable because, again, one doctor can serve multiple hospitals. Like they hold a clinic in one hospital in the morning and another clinic in another hospital in the afternoon. And you cannot expect the doctor, of course, this doctor will want to use only one consent form for all his or her patients and one platform for his or her patients. But so you as one of the many hospitals that this doctor works with cannot impose on what is the best. So that again is a challenge. So the best that we can do is to present and package as much as we can the best possible platform and forms that we can recommend to the doctors, so that at the end of the day, the doctor will hopefully have a good selection of to protect both the patient and the doctor in this in the telemedicine platform. Again, telemedicine right now is mostly consultation, like you cannot do telesurgery or something like that. Another trend that has been uh, that has been come into prominence is electronic medical records. It's EMR. For those of you in the health sector, this is already jargon. So EMR used to be brewing in the background for the past 5 years, and hospitals are trying to adapt them. Uh, but due to the pandemic, we are forced to adapt them more quickly. So what are the challenges? Not all doctors, not all patients can access their medical records online. Even doctors, not all are tech savvy, and there are many hospitals with each with separate medical record systems. And how can you give lab results from one hospital to another if a patient is transferred? Interoperability. Fraud is another concern, because um, especially in COVID test results, we see a lot of COVID test results flying around with the name and logo of our hospital and the signature of certain doctors supposedly. And supposedly these were generated by a medical record system, when in fact it is just Photoshop somewhere else, so that a person can get a free negative COVID test results for his or her purposes. So in sum, the pandemic has really forced us to speed up our adoption of what should have been slowly, things that should have been slowly learned and tried by people, processes, and technologies. And as we go along, we are more risk tolerant, because what is important is to save the life and health of the patient more, and then you just adopt whatever practices you have, so to follow how this saving of life is being conducted. That is the picture right now in the trends and challenges of digital health. Thank you.
Okay, thank you so much, Elson, for the industry insights on teleconsultation and the ongoing technical and other challenges therein. Now, our next speaker to cover the same topic of telemedicine and its challenges in the Philippines, but more from a legal point of view, is JJ Dicini, one of the leading TMT law experts. So JJ is the managing partner of Dicini and Dicini Law Office and has a master's degree in law from Harvard Law School. He's also an expert on IP, privacy, data security, and litigation. He has advised clients in corporate, project finance, securities, foreign investments, and TMT matters. He teaches at the University of the Philippines College of Law and the Philippine Judicial Academy. JJ, the floor is yours.
Thank you, Maros. Good afternoon. So my topic today is to talk about, to continue the discussion on the legal aspects of telemedicine in the Philippines. As mentioned by Elson earlier, in the Philippines, doctors are not employed by the hospitals in which they work. Instead, they are engaged as consultants. And this is because of a provision in our tort law, which says that the employer is solidarily liable, is directly liable for the negligent acts of its employees. Therefore, liability for medical malpractice, if the doctor is the employee of the hospital, becomes the direct liability of the hospital. And so as a means to mitigate its liability, many hospitals decided deliberately not to employ doctors, but instead engage them on as consultants. And therefore, since they are not employed by the hospital, they many doctors, in fact, are consultants in multiple hospitals. So that's one of the peculiarities of the structure of the market in the Philippines, so to speak. What happens is that for a doctor to have, when he becomes a consultant in a particular hospital and he has admitting privileges, one of the other phenomena that we've seen in the Philippines is that there is a building that is usually attached to the main hospital, and that building contains nothing but doctors' offices. In fact, locally, they're known as medical arts buildings. And in those offices, doctors practice, they hold their clinics there. And because they are not employed by the hospital, they basically run their clinics as their own business. And so this is peculiar in the way that it's the market, so to speak, is structured. And what this means for a doctor is that in order for him to have a steady flow of or traffic or access to patients, it is essential that he is admitted as a consultant in a hospital, so that he can have an office in a hospital, in fact, attached to a hospital, and have a steady stream of patients. What we're seeing now with telemedicine, which has exploded in the last 12, 18 months because of the pandemic, is there have been a lot of entrants now into the market. And these entrants that you're seeing now, the examples here on the screen, are not necessarily connected to hospitals. Instead, they're connected either to pharmaceutical companies, some are allied with telecoms companies, some are IT companies, some are allied with the HMOs. And so one of the things I think that is an offshoot of the telemedicine or teleconsulting, as Elson mentioned, one of the, I think, consequences might be is that it might disrupt the business model of hospitals, where hospitals can build structures called medical arts buildings and sell real estate to doctors because it's a primary and important real estate in order for the doctor to get patients. But if telemedicine can disrupt that, and the ability of a doctor to get patients is through other metrics, i.e. how well he rates, for example, in these telemedicine sites or teleconsulting sites, then I think there's a possibility that the entire sector may be disrupted. Of course, there are many concerns associated with teleconsulting or even the use of technology in the practice of medicine. I think the very first issue, of course, is practice of profession. Teleconsulting allows a doctor from a different jurisdiction to basically render a service to a Philippine patient. And under the Philippine Medical Act, that would constitute practice of profession. And in the Philippines, the practice of profession is restricted only to Filipino citizens, and therefore that would be a violation of the Philippine Medical Act. So in other words, telemedicine or teleconsulting may be seen as a platform for the violation of the Philippine Medical Act. Another concern, of course, is the ability, because of the ease by which information can be transferred or cross borders, that foreign professionals may, in effect, practice their profession in the Philippines. And this is true. I'll give an example. There are these devices which can capture the output of an ECG machine and then transmit it electronically anywhere in the world. That the ECG can be read by a foreign doctor, and that consultation or that result reading can be transmitted electronically to a Philippine patient. Now, arguably, that would be practice of profession, where the data is collected through a physical device here, but then the actual reading and interpretation of the results is done offshore. So I think that's one of the issues that will be at the fore. The second thing that we're seeing, of course, is this blurring of lines between practice of medicine and the ICT service. Of course, the platforms that provide these services always disclaim that they are not engaged in the practice of medicine, that they're merely a platform by which doctors perform their profession. And of course, the reason for that is a liability issue, where the platforms are saying that they are merely the means and they don't control the content. Third is the issue of data privacy concerns. Because a lot of the platforms are basically platforms, and the doctor, in effect, is a sort of a businessman, so to speak, or the business or the primary data privacy controller of the data. There is a sense by which the doctor exposes himself to the potential liability for data privacy concerns, because the actual use of the data is actually handed over to the platform. And it's not clear to what extent the doctor has authority or the ability to control the processing of information by the platform through which he's practicing his profession. So I think that's going to be one of the concerns that we will see. Of course, apart from that are cross-border concerns and things like data portability. So the Philippine data privacy law requires that if data is stored in a standard format, that the data subject should be able to take that data as it goes from provider to provider. So that is one of the things that I think will need to be addressed by the industry. And finally, as I mentioned earlier, because the way Philippine law treats doctors and the way the industry has responded, the licensed physician himself is sort of a standalone business person or standalone entity responsible for compliance with the data privacy law, compliance with malpractice liability, and adding digital platforms into that mix means that you're placing upon an individual physician all these added compliance burdens. So I think that's one of the concerns that licensed physicians in the Philippines will need to consider. Thank you.
Thank you, JJ. It was very interesting to hear more about the legal relationship between the doctors and the hospitals there in the Philippines, as well as the growth of telemedicine service providers and the legal issues in the telemedicine space there. Thank you very much. And now for our third speaker, from Shanghai, we have Diana Lee. She is a PRC and New York lawyer and a partner at Fangda Partners. Diana has been recognized by Legal 500 in 2020 and 2021 as a leading lawyer in individual and healthcare and life sciences, with her firm being ranked as a Tier 1 PRC firm. Her firm has also been classified by Chambers Asia as a Band 2 healthcare law firm from 2019 to the present. Ms. Lee has an LLM from Northwestern University School of Law and specializes in M&A, private equity, foreign direct investments, operational matters, and general corporate and commercial matters for various healthcare industry clients. She regularly advises multinational pharmaceutical companies or groups in their corporate legal matters in relation to market authorization, distribution, and sale model and structure adjustments in coping with the latest PRC laws and regulations. So now let's take a look at China. Please go ahead and share your screen, Diana. Thank you.
Thanks, Maran. Let me share my screen just a moment. I think that's the one. Okay, thanks. Today I have three topics for China telemedicine industry. So first of all, I will discuss about the current trends in this industry. Well, given the I think the pandemic or COVID-19 outbreak last year, so we have seen very growing numbers of telemedicine or internet hospitals that has been established in China, especially from last year. And also we have seen diversity of this kind of industry participants. For example, we now see the 5 major sectors ranging from the medical service, covering all those online reservation diagnosis service, and also to the drug circulation area, and also insurance company. For example, the medical insurance has also entered into the China market, providing some value-added service to patients. And also the industry has been expanded to health management service, including those gene sequencing service, as well as some big data and robots in providing medical service. And in the second sector, I'm sharing this very typical cooperation model between enterprise and the telemedicine in China. For example, as you can see in these slides, we have an internet hospital in the center. And what a pharmaceutical company would do, they will have a very good framework cooperation with the internet hospital. And also they will introduce their HCP, meaning doctors and nurses, introduce those HCP to be attending doctors online for providing diagnosis service and also medical service to patients who used to buy drugs at pharmacy or at offline hospitals. And by doing so, the patients will enjoy the benefit of online prescription as well as delivery service, which will be arranged by the pharmaceutical company. So in this this model of cooperation, there are a lot of data flows in between from internet hospital to pharmacy, as well as to logistic companies. And also there should be some shield or China war between the pharmaceutical company to with the individual information of those patients. And the second typical mode nowadays is AI-driven or platform-driven cooperation, where in the center of this model, the platform company, they manage to develop some AI system, and they set up the platform among all those companies. So the pharmaceutical company, they will provide know-how about how to make the health management of patients. And also the insurance company, they will provide some online insurance program, which can be bought by users of the platform to support their purchase of very expensive drugs. And in this mode, there's no, or sometimes there could be some internet hospital in between as well, but an offshore hospital will be sufficient for providing the service. It's the same situation that a lot of information, especially the personal data, will be stored, will be collected, stored, and be commercialized in this process. So that how to protect the privacy data is also a very big topic nowadays. And I would discuss in the third sector about the general regulatory compliance and data privacy issues in telemedicine. You can see from this slide, this is about some basic of online diagnosis and treatment licenses. For doing online diagnosis and treatment, first of all, you should be an internet hospital, meaning you should obtain a hospital practice license for the entity which operates this internet hospital. And also there will be no first diagnosis on the internet hospital, meaning you have to go to the offline hospital to obtain a diagnosis first. And for only chronic diseases, the online diagnosis can be applied. And there is a very clear prohibition that narcotics and psychoactive drugs cannot be allowed for prescription online. And for the licenses for HCP, the doctors and the nurses, they must, first of all, they must have relevant practice licenses. And also they need to be filed with some central data room of database for the licenses. And also for internet hospital, in addition to the basic hospital practice license, you need to hold a value-added telecommunication license. And also you need to have Internet Drug Information Service certificate and information network transmission of audiovisual program certificate if you want to post on your database or on your website about the introduction of your medical service. And compliance issue, I mean, the anti-unfair competition is also very typical issue. For example, if you, the internet hospital, they would have doctors online, and it is understandable that the hospital, the online hospital, as well as the pharmaceutical company want to introduce or want to have the doctors to prescribe more of their drugs, which is understandable. But in reality, in practice, you cannot link the income of the online doctors with the numbers of cases they introduce to the platform, as well as not to link with the volume of your sales of the drugs. So this is the very basic rule that under the PRC law, no party shall achieve a transaction opportunity or gain a competitive advantage by providing an unfair interest to the following person, meaning the counterparty, for example, your patients, and also the receiving party, also the entity or person which can have the authority or influence over the transaction. And doctors and the nurses are very typical persons with power and influence towards patients. And also for antitrust perspective, we have seen some exclusive cooperation between internet hospital and certain pharmaceutical companies. So if, for example, if a pharmaceutical company has some dominance in a relevant market, such as a relevant pharmaceutical drug in China market. So if this kind of pharmaceutical company, they sign an exclusive arrangement of an internet hospital, then it could be of antitrust concern. And also medical advertisement is another topic that we need to be focused on, because with the use of the WeChat and also the other online access to your potential users, sometimes it's very common that you will send out those introduction documents or advertisements about your internet hospital as well as your drugs. This is subject to scrutiny under the Chinese law, meaning that you have to get all those approval in advance before you can post your advertisements. Yeah, that's the incentives to HCP. I've discussed this in generally, so that the platform should be very cautious about the incentives in which form that you can provide to HCPs. And the last but not least one is the data compliance issue that we have the cybersecurity law of the PRC. We also have a new law started effective from this month. It's the personal information protection law, meaning that any misuse of personal data will be under very strict scrutiny nowadays by Chinese authorities, as well as certain, in addition to administrative penalty, there could be also criminal liabilities. And we have very clear, definitions on personal data and what kind of information will fall within the category of sensitive personal data. And the process, the word process data, process has a very wide range of definition as well, including, as you can see, collection, recording, structuring, and also your use of that kind of data in future. So the last slide tells about how to, how to comply with those basic principles. Very general view, but ultimately, I think it's the purpose of our law is to make sure that no personal data will be illegally utilized by any parties. So thanks for that's a very general discussion on Chinese telemedicine industry. Thanks, Mira.
Thank you for your excellent presentation, Diana. Thank you for sharing with us the typical business models in China and major issues and legal requirements, restrictions, or safeguards, including antitrust and data privacy rules. And next we have Abadi Abi Tisnadistra, a founding partner of Accent Law in Jakarta. Abi is a leading corporate lawyer in Indonesia, as recognized by Chambers Asia, Asia Law, Legal 500, and Asia Business Law Journal 2021's A-list of Indonesia's top 100 lawyers. His practice includes corporate M&A, joint ventures, foreign investments, compliance, financial services, financing, fintech, IT, and TMT transactions for a broad range of industries. He has also advised on many transactions of multinational investors in consolidating operations in India. Abi's technology clients include NTT, Google, Sony, and Indonesian unicorns such as the Gojek Group, Tokopedia, and Traveloka. Please proceed, Abi. Thank you.
Thank you very much, Rose. And good afternoon, Indonesia time, to fellow panelists and all the participants. It's very interesting to learn from other jurisdictions. I have to agree with the first presenter, Elson, which explains that basically the use of digital technology is not something new, right? Digital technologies for health services actually have existed for quite some time through the development of technology infrastructures or digitalizations of health data. These are the type of health technology that have evolved and developed for many years and quite recently turned into the form of telemedicine. These services during the earlier years were only provided by conventional healthcare providers such as the hospitals or the clinics. In Indonesia, the term telemedicine first briefly introduced in 2015 in one of the Ministry of Health regulations, but it was for only a limited purpose in which the regulations briefly mentioned that provisions of the health services through telemedicine is combining technology and health access, specifically in remote areas. So this is very limited. But then in 2019, there's another Ministry of Health regulations which redefine telemedicine as services using the medium of technology between one health service facility and other service facility. So again, it's still quite limited and between conventional healthcare providers. Now, the game changer is the introductions of the universal healthcare insurance in 2014, which basically changed the Indonesia's health landscape. Because with this government program, it means there is a greater demand for health services and for sure more funds and money in the health system. So in the last 5 to 8 years, a range of digital health companies and digital health solutions have emerged in Indonesia. And telemedicine is only part of a number of digital health providers that currently in operations in Indonesia. And based on the publicly available data, currently there are more than 170 digital health service providers in all different types of forms. There is a reason for this significant growth because there is a need of proper health services access. Indonesia have more than 270 million population spread across over 17,000 islands. So technology will boost the possibility to give access for Indonesian populations which lives in remote areas. At the same time, we also have shortage of trained medical professionals, the like of nurses, doctors, therapists, and not to mention shortage in health infrastructure such as hospital equipment and other healthcare facilities. So there's a lot of room for digital health companies to grow, right? But at the same time, despite the significant growth, the Indonesian government is yet to specifically regulate digital health applications. So at the moment, there is a gray area where digital health applications are operating. Although there are a lot of discussions among the industry, there is at the moment already an associations which become the umbrella of all of the health tech players, doing close discussions with the regulations and expecting sooner than later that this area will be further regulated. At this point of time, the regulatory bodies that supervise the digital health sectors in Indonesia is the Ministry of Health. And very recently, the Ministry of Health just established a digital transformation office. So it is a sign that the government take the development of digital health sector very seriously, and the digital transformation office is quite active in liaising with the industry players, at the same time trying to boost the usage of digital health applications whenever possible, especially during the COVID-19 pandemic, right? And the other regulatory bodies that also relevant is the National Agency of Drug and Food Control, because they supervise the distribution of medicines offline and online. And given the fact that there is information technology element of digital health providers, then it is also under the supervision of the Ministry of Communications and Information Technology. Right. Now, the driving factors for the growth and the adoptions of digital health in Indonesia, like I've already mentioned earlier, lack of access, and with the boost of technology, it is expected, right, that the growth of digital health in the near future will getting more significant, especially when all the infrastructures are already in place, right? Indonesia is recognized as one of the countries with the highest internet penetrations and the number of users of smartphones. So now it's easier for those who have no access to health facilities should be able to at least getting telemedicine consultations, as Elson referred as well. At this moment, when we're talking about telemedicine, then most likely the most crucial element is the consultation part and not really the physical assessment part, right? But what actually accelerate the adoptions of digital health in Indonesia the most is similar like in the Philippines, of course, is the COVID-19 pandemic, right? Because 2014, 2015, when the first few digital health providers came into the picture, the growth is pretty slow. But then in 2020, there was no option, and it seems that the role of the digital health providers, especially those who providing healthcare ecosystem to the users, are getting more popular. And during the peak moments of the COVID-19 pandemic, only June, July this year, hospitals throughout Indonesia were on the verge of collapse. They cannot keep up with the number of patients. And at that point of time, the government encouraged the usage of telemedicine applications. So to avoid those who are not infected by COVID-19 to still get access to the healthcare facilities, or at least consultations with relevant doctors. And now, thank God, the COVID-19 pandemic, although it's still here, but it's not as troublesome as in the mid 2020, 2021. But the habit of using digital health application is still there. And these are basically just samples of digital health platforms in Indonesia. The telemedicine platforms is basically run by the conventional hospital groups, right? And the government also quite recently setting up their own integrated telemedicine services called Temenin, and the remaining is basically just the two largest digital health providers in Indonesia. Now, when we're talking about the licensing requirements and compliance, in short, there is still no specific licensing requirements for telemedicine platform in Indonesia, except for those who providing online distribution of medicines, which will be subject to specific approval by the Ministry of Health on the integrations of online medications distributions. But as a general concept, aside of specific license, on the health sites, being an electronic system providers, the digital health applications or telemedicine providers have to also comply with the regulations, permits, and requirements under the Ministry of Communication and Information Technology, and whenever relevant, the Ministry of Industry as well. As you can see in these slides, there are actually a number of regulations that was issued very recently, and specifically to prevent the spread of COVID-19. This is actually the basis of the provisions of telemedicine in Indonesia at the moment. Although the regulations limit that this telemedicine coverage only available during the COVID-19 pandemic, but again, given that the industry has grown quite big, the likelihood that it will stay even if the pandemic is no longer around. Next, on the data privacy issues. I think the biggest problem with Indonesia is at the moment we still have no law on personal data protections. It has been a bill for many years. A lot of expectations that this will be a game changer, and the word on the street that this is being prioritized to be enacted within this year. But the same information was also similar like that last year. So a lot of expectations, but at the moment, data protection regulation in Indonesia are scattered around in more than 30 regulations. For medical data, the health law, to some extent, give protections on information for patients and medical records. Right? And then there's also regulations on health information system. Interestingly, there are a lot of inconsistency between the definitions. The government regulations, for example, define health data different with the patient's health data, so it's more like an aggregated data, right? And basically, we have at the moment, no definitions of sensitive data or health data. It's not specifically defined as part of a sensitive data. So a lot of, again, expectations with the draft bill on data protections. Just to share a bit of it, the bill actually acknowledged the concept of sensitive data, which shall include also the health data. But from our assessment on the latest bill, although it has defined sensitive data, it does not differentiate how the sensitive data should be treated and processed, unlike in some other mature jurisdictions or the GDPR regulations, or I think Diana mentioned about the treatment, self-data treatment in China. In Indonesia, I think we're still way behind, and the expectation is after the issuance of the PDP bill, there will be implementing regulations that will cover these issues. One last point that is very important. At the end of the day, the main issue for data privacy in Indonesia is clear and effective regulatory regime, right? And a very recent incident in Indonesia is the database incident, in which one of the applications maintained by the governments to trace and monitor the COVID-19 spread, which also contain data, various health data, including COVID-19 vaccine certificate, were actually leaked into the public, right? And this is actually not being treated seriously at first until the data leak shown informations on vaccinated of our president. Now it's become a very big news, but it shows that how even the government is still not treating data protections properly, right? And this is gonna be something that needs to be fixed in the near future to ensure a better protections in data protection regime in Indonesia. I think I ended my presentation here, Maros. I'm giving back to you.
Okay, sorry. I muted and unmuted myself. Anyway, we would like to cover India. Thank you so much, Abby, for your presentation. So Pankaj Singla is the co-founding partner at the law firm Acumen Juris, Pankaj has more than 12 years of experience specializing in multi-jurisdictional transactional work across various sectors. Pankaj has also worked in Tokyo. Actually, I worked with Pankaj before. He regularly advises clients on M&A, joint ventures, private equity and startup funding, employment law, competition law. Sorry, the list is very long. But anyway, he has really been very good to his clients. So Pankaj, the floor is yours.
Thank you, Maros. And Abdi, if you can just stop sharing the screen so that I can upload the PPT. Thank you. All right. Hello, everyone. And Maros, thanks a lot for arranging this and everybody's views. So, as due to the paucity of time, I'll skip through some of the information which is related to the regulatory framework or introductory remarks. So I'll just quickly give you background on the current legal framework in India. That's the Information Technology Act, which is basically to govern the privacy laws, and the Drugs and Cosmetics Act, which is for the manufacture and sale and of drugs and medical devices. Indian Medical Council Act, which basically governs the professional conduct, etiquette, ethics, uh, as well as the medical education in India. Clinical Establishment Act is for regulation of the hospitals, clinics, etc. in India. So quickly coming to the challenges in the healthcare sector, digital healthcare sector. As we have heard from other panelists, data privacy seems to be one of the major issues or the concern in this particular sector. It's the same with India as well, because the current laws provide a very limited framework for the protection of the data. Uh, One, they are old, and two, there are mainly because of that they have not kept up with the changes or the development in the technology. Uh, for example, the data privacy law that lacks in some of the issues is it while it tries to protect the digital data of a patient or a health data of a medical data of a patient, there is no real restriction on anonymized data of any patient. So that is one area where it lacks, because the data has to be that the data that is protected has to be capable of identifying such a person. Now, another issue is, while there are consent requirements under the law, consent before collection or of the data or the processing thereafter is, or the transfer of data is required, a user can be declined services if they refuse to share that consent, which is not really an option in when you're availing medical services. So that is another area where it lacks. While there's also procedure for withdrawal of consent, it's basically a writing email or a letter you need to send it to the concerned company that has collected your data, and whether that consent has been, or the withdrawal request has been complied with or not, there is really no real way to find that out. Another is, there's no real regulator, there's not a dedicated regulator who's looking after or working to protect the data privacy of users. Individuals really have to deal it on their own, go to the court or file a police complaint in case of a data breach. Another challenge we have seen is the e-pharmacy, uh, which is supply of medicine, online platforms. While those platforms do exist in India, the existing framework does not provide any support for that or regulation for that. There are some pending draft rules that are pending, but those has not been implemented so far. As well as there have been decisions of certain high courts in India. The high court is the highest court in a state in India, and the decisions have been conflicting. So that is also a concern how we are moving forward with that. Another challenge is the digitization of health data. Uh, Doctors as well as some patients are still working the old way or the traditional way, where they go and meet the doctor, and there's no digital framework being used. Although there have been efforts by the ICMR as well as other regulators to digitize the health data, uh, at present it's still a challenge. But with time, it seems like that it would not, it would we will see a lot of progress in this area as well. Again, there are practical challenges that I think all the panelists have mentioned: adoption of technology, accuracy of diagnosis, accountability is another discrepancy. It's not clear what happens in case of a mishap. Now, COVID-19 was, in a way, it provided us with some measures where some measures were taken by the governments. The government of India permitted the doorstep delivery of medicine, that is the e-pharmacy, on a temporary basis in order to reduce the number of people going out to get medicine. Now, this is a temporary measure. We don't know until when this is applicable. But we'll have to wait and watch. Similarly, telemedicine practice guidelines were issued in 2020 by the ICMR. So that has been a very good development because it clarifies the legal position on teleconsultation. It regularizes the norms and protocols relating to the doctor-patient relationship. What is exciting is the legal framework that is proposed. Now, there's a draft personal data protection bill, which basically was mandated as the Supreme Court of India interpreted data privacy or the right to privacy as a fundamental right under the Constitution of India. The problem is the data protection bill, which although provides much better data protection compared to the previous one, as well as it has proposed setting up of an authority, dedicated authority that would deal with any of the data breaches, and also will create standards on a regular basis on how to protect data. The bill has not been passed. I think one of the main reasons would be there's a disagreement with the industry wherein the criminal consequences of data breaches are being provided in the bill. Health data is covered under sensitive personal data as has been in the past law also, but health data being covered as part of sensitive personal data basically provides stricter norms to deal with such data. Now, data protection bill, while it's a general in nature, it covers all the industries and sectors. Digital Information Security in Healthcare Act, which is also proposed law, again pending because it's being debated so far. This is a more sector specific. It's meant to basically provide extra protection, dedicated protection to the healthcare data in India. Now, it has better enforcement of privacy and security measures for health data. The user consent is required at every stage. At the time of collection, at the time of transfer, at the time of processing, user can withdraw the consent anytime. And the best part is that even if the consumer or the user withdraws their consent, the services cannot be refused to the person. There's an absolute restriction in the proposed law for sharing the data with pharmaceutical companies as well as insurance providers. That is a big step. Under no circumstances, practically, they are allowed to access data except for processing of any insurance refund. So Disha, the new law empowers the users to refuse consent any time of at any stage of data collection, which is also a big step forward, and it seeks to provide a more formalized mechanism to do that. Similarly, draft pharmacy rules which have been pending for a while. We are hoping that sometime soon they will be implemented. Now that basically bridges the gap in current regulations to govern e-pharmacies or delivery of medicine at home, and formalize how those companies can get registration with the government or the relevant authorities. So that's it from my side. Sorry to rush you through this because of the paucity of time, but appreciate if you have any comments to me or to any of the panelists, we'll be happy to respond. Thanks a lot, Maruz.
And thank you for your presentation, Pankaj. There's really a lot of regulatory gaps that need to be addressed in the different countries. And hopefully we can have another webinar on this topic just to see those developments. In the meantime, thank you all for joining us. And for the questions, I believe have mostly been answered. Or wait, is Abadi still answering it? Okay. Well, thank you so much, Chris. Chris is a friend of mine, actually. So thank you so much, Chris, for all your questions. I will actually list them down, and I will have the panelists email you their answers since we have run out of time for the Q&A session. We're going to skip to the networking event, and I will request the IPBA to share again the link for the networking event. So just click on the link. You'll basically exit this webinar and then join the networking session where we will see you again, and you can ask all the other questions that you want of the panelists. And so thank you, and wish everyone good health. I hope to see everyone in the networking event. Thank you.
Thank you, Morose.
Thank you.
Thank you.
Thank you. Bye-bye.
Thank you, Morris.